So what is arbitration and what is an arbitration clause? Stick around in this video and you'll learn all about it. Brian Flores, former head coach of the Miami Dolphins and also coordinator for the New England Patriots and other organizations, has sued the NFL. Now, usually an employee of an NFL team which sues the NFL would be required to go to arbitration. Okay, arbitration is where the two sides go to a supposedly neutral person that's going to hear all the facts of the case, all the evidence, and make a decision that's binding upon both parties, meaning they both have to accept it, no matter what it is. Except the NFL, their arbitration agreement is embedded within the collective bargaining agreement with the players, and some of the coaches have agreements with them as well that say that basically the final say on an arbitration goes to the commissioner, Roger Goodell. Except that would be like an employee suing a corporation and the CEO of that corporation being the decision maker. How could that be fair, right? You're suing the corporation. He represents the corporation. He's the opposing party. He shouldn't be the neutral arbiter. So what happened here is that the Second Circuit Court of Appeals, which is in the New York region where the NFL is headquartered, the Second Circuit Court of Appeals, the federal court level Court of Appeals, has decided that that clause of the arbitration agreement is not reasonable. It's not appropriate. It's not legal. So they're going to allow Brian Flores' lawsuit to proceed in the federal court in New York and not go to an arbitration. That's enormous news for anybody who's an employee of the NFL and really probably any sports organization, or really largely most major corporations around the country, because a lot of them in their employment agreements, whatever type they have, include arbitration clauses. Now, how does this apply to what I do? Okay, arbitration is something that you see in a lot of different contexts. In the context of personal injury, a lot of times parties can agree to go to an arbitrator, and that will save them a lot of time. It'll save them a lot of money in legal expenses. It'll take a very formal process and make it more streamlined. It can be a very efficient way to resolve a case between two parties that can't agree and can't settle on their own. This is called alternative dispute resolution. So arbitration is a very effective tool depending on the case. In personal injury cases, what we do is we may say to the other side, to the defense attorney or to the insurance company we're dealing with, do you want to try to go to arbitration? That is a way to make sure that a neutral arbiter, just like a jury would or a judge would, a neutral arbiter who's qualified in the field that both parties agree on. We look at their qualifications, how much they cost, et cetera, and we decide this is the arbiter that we think is best for this case. We agree, we submit our papers to that arbiter, we go in front of that arbitration and we submit evidence, we examine witnesses, we make arguments just like in a courtroom, and then the arbitrator will make a decision. And that decision will come out in a memorandum and an order, and it's binding. All parties have already agreed to whatever the finding is before the finding comes out. Unfortunately, in the NFL situation, that's really not exactly how it works. The parties don't choose the arbiter, and the final say would go to the NFL. It's completely backwards. It's really not the spirit of what arbitration is, which is a neutral, binding way to resolve cases without using the court system, which is very burdensome, very expensive, very lengthy, and very public. So Brian Flores did a lot of people in the NFL a major service by pursuing this lawsuit. What's really going to be interesting to see how it turns out. He was a great coach. It's going to be sad that he's not coaching in the NFL anymore. So where else do we see arbitration in my work as a personal injury attorney? One place that we see it all the time is in what they call first-party automobile insurance claims under the U claims, or the uninsured and underinsured motorist provisions of your auto policy. So from time to time, a person will get in an accident and the driver that causes the injuries, the driver that was negligent, injures you, but they don't have enough insurance coverage to protect you and pay your medical bills, your lost wages, your pain and suffering, and other general damages. So you can have coverage on your own insurance policy to, bridge that gap, to make sure you have more available insurance benefits to you in the event you're injured in a car accident. Well, if you decide to bring an underinsured motorist claim, you have what's called an arbitration clause in your insurance contract with your car insurance company that requires that if you don't agree on a settlement, the mechanism for you to proceed is to arbitration. And that's a fair clause because it still requires the parties to agree on the arbitrator. And the process is fair and unbiased, and generally speaking, it works. That also goes for the uninsured motorist provision of your auto policy. The uninsured motorist provision, the different part of your auto policy, is the same concept. If someone that causes your injuries does not have insurance, or if they hit and run and you don't know who they are because you can't track them down, in those contexts, there's also an arbitration clause within your insurance contract that if you can't agree to a settlement with your own insurance company to cover your losses as a result of some other person's negligence who is unidentified or who didn't have insurance, then you'd go to an arbitration, you'd choose the arbitrator, and you'd go to a very fair and unbiased process. There's a little bit of a disadvantage for plaintiffs, for people who are injured in this situation, because insurance companies always offer the arbitrators more business than a plaintiff's lawyer or a plaintiff can in general. I mean, one plaintiff might be injured and have one case and one arbitration their whole life, but an insurance company offers these arbitrators, dozens, if not hundreds of cases a year. So it's a little bit of a disadvantage, but it's way better than the system that the NFL put into their collective bargaining agreement for the players or coaches, that the arbitrator is the CEO of the NFL. That is a system that is just so flawed, it's unbelievable. The person who is responsible for the injury should not be deciding what the legal rights of the injured victim are. And that's not how it works in personal injury cases, thankfully. And most of the time with these arbitrators, you'll find that they're fair and impartial, and they do their best to be so. It's important that you hire an attorney that knows which arbitrators are the ones that are fair and impartial and which ones are in the bag for the insurance companies. But this is really an interesting way for a big story, and that's the Brian Flores story, to educate the public about a major legal issue. And this alternative dispute resolution is a very valuable tool if it's done right and done fairly.